Hello, and thank you for joining us for the last episode of the Patent Analytics webinar series. Today's episode will cover using patent prosecution history reports to increase prosecution efficiency and avoid unintended estoppel. A webinar recording and the slides will be emailed to all registrants. Please feel free to enter any questions using the Q&A feature on the Zoom menu. And with that, I'll hand things over to Steve.
Hey, thanks, Michelle. Welcome everybody to our final installment of the analytics series. And today we've got with us a couple of familiar faces again. Janelle Callis, who's principal at Schwegman and very senior expert in FTO, patent analytics. And Janelle is an expert in various different tools. And also the author of the Patent Buddy blog, which she's got a very large following on Twitter. If you ever want to hook up to that, it's an excellent blog or Twitter account. And then we've got Peter Ribafoni, who's our legal process manager at Schwegman. Peter's been with the firm for a long time and is an expert in all areas of legal process. And by what I mean by that is organizing all of the tools and people that essentially deliver our back office services to our customers. And Mark Stignani, who has been on the series every episode so far. And Mark's our analytics chair and firm compliance officer and former chief patent counsel at Thompson. So with that, let's roll into the presentation. So today's presentation is a little bit more proprietary, I guess I would say, in that it's focusing on some practices that and tools that Schwegman uses that are, not widely used outside the firm, although the tools are made available by Black Hills IP for some uses by some of their customers. So really what we're talking about today is methodology for capturing prosecution history data and then storing that in an organized database and then providing that to attorneys like automatically, so that when somebody picks up a file to do an amendment or file a continuation, they have a report that we can generate with a push of a button, literally, that gives them in one place all of the information about the history of all the claim amendments that have been made in all the family members, all of the art that's been cited across all the family members, all of the rejections that have been made, all the text of those rejections, and then also all organized by claim and by reference, and then also the amendment arguments that have been made by our team at Schwegman. And that's very nicely structured so that instead of having to dig through multiple different files and open up, go shag a bunch of paper files, which nobody has anymore, or try to drill into electronic files, you've got it all in one place. One of the biggest background demands for these types of things is if you go back in history of patent prosecution, maybe some people still use threefold paper files, file wrappers, but very many people have gotten away from that because everything's online. Well, those files were really great for flipping open the file and taking a look in there, digging through it, because all this information can be laid out. All these pieces of paper can be taken out if you want and spread out. You could get the whole stack of files for the family of cases and look at all of them. And back in the day, so to speak, there were fewer history files for fewer family members because there just wasn't the continuation practice. There wasn't as much international filing. And then what's happened over time is all this data now is migrated into databases, and it's instantaneously available 24/7 anywhere you are in the world. The problem is it's hard to get access to all the pieces of it at once that you need so you can take it all in before you start writing a response to an amendment. And a lot of times, as we all know, we're all under a lot of time pressure to generate high quality product in the least amount of time. So how do you make that better? As you figure out better ways to bring that information to the attorneys, so that they don't have to put any effort into getting the information, because people will look at information if it's easy to get. And if they have to spend 2-3 hours just to collect the information, or even 45 minutes or even a half an hour, a lot of times they just don't even have time to look at all of it. So they kind of look at what's most relevant and sometimes not look at everything, if they just don't have the time. So this is a way to really shorten up that whole process of gathering data together for people to have when they start an amendment. So basically what this database we're going to talk about today is called Claimscape. You want to go to the next slide, please? And basically it contains all this information that we gather as we prosecute, and then we can pull it out of there and give it to the prosecutors or other people that want to use it for different purposes. So it's used by patent prosecutors in prosecution. It gives you family claiming overview. It allows you to basically avoid inconsistent arguments, reuse successful arguments, figure out which art has been used across multiple family members. Was it cited in Europe and also in the US? And what did they use in China? Gives you the big picture, which often is lacking in patent prosecution because of the tendency to just keep the little, ant-like persistent. You move a grain of sand, but you never stop, get back and look at the anthill. So this is an anthill, just viewing device, if you will. So you look at everything and not just your little grain of sand.
And Steve, if I could just jump in for a second. For those people on the call who aren't fully into patent prosecution, or maybe they're doing licensing or other things around patent prosecution, this is a really great tool for just understanding what might be encumbered if you're offering a set of patents for a license, or somebody's coming to you with a licensed set of patents. This is a great tool to go to a lot of other analytics from just patent prosecution as well.
Yeah. So, so it's got non-prosecution application, and and if you're working on a high value prosecution, you really got to be careful about saying things inconsistent, between inconsistent arguments in between your EP and your US, or you file your first US case 10 years later, you're still prosecuting. So it allows you to see all those arguments in one place and not basically be inconsistent, which can cause, as everyone knows that does prosecution, a lot of problems in interpretation of the patent. So to the next slide, please. So I'm going to turn it over at this point to Peter Ribofoni, who works with Claimscape, our internal tool, as we call it. Peter, you want to take it away from here, please?
Absolutely. Thank you, Steve. Just building on what Steve said, our biggest goal is to get everything in one place when the attorney needs it, and to integrate these reports into existing workflows. So, the way we do that, and on the prosecution side at least, is to get all the documents in place when a new action is received. So, in the example of a case that you filed, building up a file wrapper in our database of the claims as filed, so that when a first office action comes in, those rejections can be parsed out. Our claim amendments, any claim amendments made are already present, and the references that are being relied upon in those rejections are also parsed out. So we start by ingesting, at the same time as we're docketing our office actions, ingesting the office action and OCRing it and parsing out the various pieces that need to be brought back together for the reports. Next slide, please. So Claimscape is where we will place in the parsed pieces of the office action. So we'll be taking things like the art that's being relied upon for rejection, the rejection type, the language of the rejection, and parsing those into various pieces. At the same time, being able to later search this data is another reason we're thinking about this as we're parsing this and not just placing an office action in as it comes in. So once you've kind of parsed out the different pieces, it allows you to go and slice the data and pull it back into a report in various ways. So for instance, a report, the citations for a given reference and the different types of remarks that are made against that reference can be easily pulled together. Additionally, you can pull in all the citations for an individual examiner if you have a common examiner across many cases, which is often the case in large families. You can see common rejections and also common arguments that overcame those rejections. Additionally, if you are also capturing art unit, because cases do get handed off from examiner to examiner or from primary to secondary examiners, you can actually go even more broadly and see what kinds of art is being commonly cited in a certain art unit against your cases.
Peter, if I could interrupt too. Well, a lot of what gets this tool really great results is the level of granularity that you're getting into here, whether you're looking across a single matter or family matters or across several matters. You're looking for either assertion, defense, or weaknesses, and you can go as granular as you want. So all the grains of the beach are here.
That's a great point, Mark. And once you have access to this data that you're constantly loading into the system for use in regular reporting, you can do a lot with that data. A great, for instance, is after the Alice decision, being able to extract all the Alice 101 rejections for a particular client or for a particular technology, and to be able to see what's been successful and see that immediately. Next slide, please. So as far as integrating this into the workflow for us, when you're doing prosecution, it's really helpful for these reports to come in a timely manner. So we strive to make sure that we have up-to-date data at any given time. So the minute we receive a new office action, I think we receive on the magnitude of 700 plus US office actions each month, we can load new rejections and art that's being cited into a matter, and at the exact same time as the attorney picks up the office action, they have a report showing what are the rejections we're receiving, what types of rejections are we looking at again, and what's the history of the amendments have been made in the case. This can go for allowances as well, where you can instantly see what claims have already been possibly restricted out and elected to look for divisional opportunities.
And Peter, I just would add that that's for every member of the family. So it's not just the case they're looking at, but it's all the related cases in that family. So you basically got a panoramic file history. And one other point here on this, which I think is important for clients, is that Schwegman doesn't actually charge anything extra for doing this. We do all this at our own expense, so that when we're doing responses, we've got the best data available for our attorneys. So when they start out doing an amendment, they've actually got a leg up on anybody that doesn't have this information in front of them. So Peter, take it. Yeah.
Oh, absolutely. And it's the equivalent, going back to that trifold example Steve used, of having the entire family sitting on your desk with the current office action and with the report showing what the history of those cases are, without having to actually accumulate those and fish through those files. And so, yeah, we in our common prosecution practice, these reports will be generated, timely with the office action being received, a draft response automatically created for the attorney to work from. And a lot of clients, because we just do this for our internal folks naturally, a lot of our clients require us to send this to them with a report out so that they can see the history that we're seeing, and in one easy to read report. And the same thing goes for any step of the prosecution where we really want to be able to see what's happened to date. So, integrating that into the workflow is something that we've managed to do over time. And it's a simple process now where we can button down these reports in a timely basis.
And it's a step away from prosecution workflow. FTO workflow is also something that we use these prolifically in because this allows us to work much more efficiently to see if we're looking at prosecution of 10 or 15 matters that are of interest to us. We can start to discover what sort of estoppel, what sort of utterances were made during the examination that help us really kind of zone in on various arguments to move that particular matter out from under our review, and thereby save us time and save the client money in our FTO analyses as well.
Yeah, absolutely. And everyone has the tendency to not want to wait to ask somebody for something that they need, and they'll just dive in. And really, this report's such a time saver that we're saving, if we have it in front of an attorney right when they need to work on the case, we're saving the time of having to compile their own sort of roadmap of what's happened in the case so far. So next slide, please.
So I think I'll jump in here if you don't mind. I mean, this is kind of presentation isn't largely just for attorneys, but just one of the things we promised on this analytic and prosecution roadmap is how we avoid prosecution history estoppel. So for those unfamiliar with the term, it's basically up here, whatever you make statements in, you can make statements that are then oral statements, which are then reduced to writing in the examiner's amendment. So basically the whole goal here is to not say things in your prosecution that would limit you down the road to make doctrine of equivalence arguments, largely based on the key case of case law here is Festo, of course. But the whole point here is that it's very hard to understand what people have uttered during prosecution unless you have the summary format where you can very, very quickly look at what the examiner said, what the arguing attorney or the arguing applicant has said, and also very quickly see where you can get utterances or oral statements reduced to writing in the examiner's amendments. These are also places where you look at the RCEs, because in many cases you will have, for the sake of expediency or sake of continuing prosecution, attorneys may file an RCE where they're not quite clear on where an examiner's basis for rejection has been ambiguously stated or unstated. So one of the things that these tools give us is a mapping aspect that allows us to very quickly see where this prosecution history estoppel may reside. Also, for you in-house people on the call, when you're talking to your outside counsel and you get this in front of you, generally in 10 to 15 minutes, you can get to where a very complex file history has been presented to you, or a series of family file history have been put in front of you, so that you can articulate and see where your attorneys, whether they're 1 or 10, have gone with this family, and it's fairly easy then to see where you can go with your claims or where you don't want to go with claims, because then you can overlay where your product is. So, Janelle, Steve, especially, do you have any other thoughts on this before I move to the next slide?
Not me. Janelle?
Nope, not me either.
All right. Well, then, since this isn't really about prosecution history estoppel, let's move on. So we can talk about kind of how we do it. So these are just cuts and pastes out of our basic file histories, summaries. We like to get everything bibliographic in front of the user right away so that you can understand where your assignment chain is. We can see where your art unit is, where your examiner is. Basically get everything that is, to establish your basic understanding of what we're reviewing with you up front. I really like the assignment chain, because this is one of the first places I look for in government, is if I'm doing an FTO, especially this will tell me if there's been a hiccup someplace. So below here, and we can certainly make one of these available if you guys want to look at this in more depth and detail. This is a non-client small inventor matter, so I don't know if we could certainly include this in the distribution list for those who want it. So we talk about class and priority and all those other baseline items. And the rest of the panel here, please jump on in if I'm not highlighting something that you feel is important here. But so this is the first tab we look at. The next tab, next slide, please, is we start with procedural history. Now, this is a, as you can probably tell, it's in a cell spreadsheet in format. It basically puts the claims of the matter before you from claim 1 to claim N, puts the actual procedural history of each claim in front of you by application date, chronologically next to first office action, any amendments. So you get essentially a tabular timeline of the claims and of the process that's gone through it. Now, this tab shows you whether you've got a new, original, amended, or a canceled set of claims. It goes by the PTO event, but it shows you the rejection aspect to it as well. There's one thing on here that's not mentioned. We also cover double patenting rejections as well in this area as well. So I'm sorry I didn't add that to the thing there. But one of the things that, when you're first starting to look at your matter, you want to know where it's been, what you've tried, and kind of, what level of rejection has gone through this. And if you're cognizant of your examiner, you can start to see, examiner behaviors in this one where, their favorite thing is a 101 or a 103 or 4. And you kind of just get a quick sense for what you've done, especially if you're picking this file up new from somebody else or another law firm. You can see where they've succeeded or where they've failed with this particular examiner, this particular matter. And panel, please jump in here before we go on to the next tab, or if not, we'll go on the next slide. Next slide. And then the next tab, it shows you all the amendments. So it shows you what's been canceled, what's been amended, what's been selected out by restriction. And you can start very, very quickly to see where prosecution history estoppel happens here. You can see, well, you see a lot of red. So that's the first place you're going to look for what's been given up. And you look at what's been deleted, and you start to see how the narrowing and where the narrowing has happened very, very quickly. Now, what's important here is that if you have a number of claims that are apparatus claims that are claiming similar items, and you have dependent claims below that, you can start to look at the various cases where you can avoid prosecution history estoppel by maybe amending a dependent claim to make it more broad, or other things there. But if you're going to start by amending down your broadest claim right then and there, this is where the standard example of prosecution history estoppel starts to occur. So and then on the FTO side, when I'm looking to see how good a claim set is after I read the scope, as its final format, I'd like to go back in here and look at all the red and figure out at what point did they give up something that I need to worry about. So in many cases, this is just a very quick tool to glance at how the claims have been narrowed over time. Again, same chronological format as before, and not a ton of extra reading involved here. So I like, less reading is always better for me to get something done quicker.
I was just going to mention quickly, Mark, is I always introduce new attorneys to our firm to this report. And this tab of the claim language across history is always one that they, brings sort of, oh man, I wish I had this at my previous firm, because the time spent trying to document and figure out what's been amended and what's been struck through at this in one tab of one report is super useful.
Absolutely. And for any of you who practice in the chemical arts, we'll talk about this a little later, when you get through, especially if you've got long convoluted claims, extensive family relationships on a particular line of patents, this is a time saver. In many cases, it's a lifesaver. In I think that prosecution-wise, you get you just get so many advantages by looking at this format than trying to read in context, a stack or a PDF that's 170 pages long, or 1,000 pages long, or whatever you get engaged with, and then you compound it by looking at multiple patents, whether it's a family or it's multiple patents owned by multiple owners. This just is really a time saver, and it's not available anywhere else. You can't find this. You can find some of the functionality in the commercial systems. You just can't find this elsewhere because it's not something you really can always generate, by machine. You have to have some human interaction, some human interdiction to make sure this is actually as represented in the file history. So so I realize there's a number of commercial providers on the call here. So this is definitely a hybridized machine plus human report. Anybody else? Otherwise, let's move on. Okay, next slide.
So Mark, I would say it's hybridized, but it's not. It's all generated automatically, but there are some steps in there that, in some cases, we use people to help make sure we get it in correctly.
Absolutely, it is hybridized, and that's where I think the why this is unique to the industry. I think is I just want to make sure that this isn't just something that I mean, Steve is very modest, and he's one of the predominant thinkers on this area, and this is one of his constructs that makes our firm very, very special and efficient. So moving right on to the applicant and examiner aspect. Now this is where the rubber meets the road, I think, for a prosecuting attorney. It's also where when I'm working in FTOs, this is where I start to look for the non-obvious prosecution history estoppel, the non-obvious aspects of encumbrance that come down in this area. So this is where I have to do the most reading, but it's also a place where I probably find the most meat. If I'm looking at a licensing approach, usually a sophisticated licensing approach will have the previous slides kind of sussed out and understand kind of what the restrictions are. Very rarely do they get down to this detail, especially if they're in a hurry to go out and license their stuff. So this is why I think if you are involved in licensing, or if you're with the university, you certainly want to look at this this tab to make sure that you have not encumbered yourself either in an examiner interview or things that you say as you're arguing why something is novel, non-obvious, and functional. So this is a very, this may look fairly simple to you, but it puts the arguments, the back and forth, the point and counterpoint between the examiner and the applicant's arguments in a very crisp format where you can figure out with, again, 10 to 15 minutes of effort, what was given away during examination. Anybody else, or next slide? Okay, argued reference tab, again, another way to speed yourself through prosecution, basically linking out to the particular matters, references, how they were impacted or used in the examiner, and kind of give you entire context of how to deal with your citations in the in the particular matter. Matters of the cited reference in common. This is also more important when you get to a family discussion. So, again, as you're going through reviews of these particular references, you're starting to read them in context to argue back with an examiner. You start to see, you look at these references. This is probably less important in a licensing or FTO activity unless you are really going into, say, a post-grant review format, where you want to look at did the examiner construe or misconstrue a particular reference? Is there more there than the examiner actually argued, or was the response made by the applicant on point, or was something glossed over. So this is another tab. You get really far down into the weeds, and you actually get into little paragraphs and sentences in the references cited, or that were cited in this particular matter. Anybody else on this one? How else do you use this? If not, let's move on to the next slide. And then this is finally kind of a reference detail. I mean, this helps, working in your, your analysis where you're looking at something where it's cited by an IDS or the examiner. And this is just, a very nice help tool that, gets you quickly to the links and the various patent matters that were cited, and kind of how they were received, how they were put into the process. So, this is definitely the detail slide here is so, also very useful, but it really gives you a holistic view of the matters. Now this, when you're looking at multiple matters, again, you go outwards and you start to look at what's cited in common, especially if you're prosecuting across an entire family, you want to make sure the references in co-pending applications are getting cited in IDS. So yet another use for this type of matter when you get out to multiple versions. So this in and of itself is very useful for an individual prosecutor, but when you start to get out and look at a licensing stack, or a family continuation discussion, or even a targeting exercise, how do you make a particular set of patents or a particular family of patents address a particular product feature for an evidence of use. This is very important because you want to make sure that all the references and citations are being commonly co-cited. If you're the filer, or if you're not the filer, then you can start to see where the prosecuting firm may have slipped up and not been forthright with their co-references. So anybody else on the call? Or
yeah, I found the status portion of this report to be very valuable with respect to determining who cited the reference, especially across families. It allows you to see what was first cited by an examiner, and did the applicant then cross-cite it appropriately.
Could you give us a little more kind of Janelle, on how you use these reports in your own practice?
That's probably the big thing, is of course to get the basic information as far as the title, inventors, filing date, of course, but also the additional data that isn't, well, I guess it is on the face of the patent, but it's nice to see it in a form like this, is to see what references were received from the examiner and what references were provided by the applicant.
Great. Well, let's move on here, kind of to the larger picture of how everybody uses these things. So we've kind of divided this out in how we use these reports as a law firm, as well as how we see clients using them, and in other uses as well. One thing that's I don't think it was stated in this, but we've covered this in an earlier segment of our analytics, is that our claim mapping tool is also integrated with this, so that as we are putting these file history reports together, we also can use them directly feed into our larger claim mapping format, which, again, for those who missed the call, is really what we use to kind of look across the landscape, quickly knock things out that have common claim scopes or common claim limitations that help us very quickly put large FTOs together. So just want to make sure that everybody understands that this tool we're really only talking about one facet of the ClaimScape tool here, and we've covered it previously, and it may not have been as clear when we talked about the claim mapping aspect. So in general, this is, as Steve has mentioned, as Janelle's mentioned, this is primarily focused as, how fast can you get through a prosecution by condensing and concentrating the information that you need to make arguments with and around. How quickly can you see what's been limited, what's been opened it, and how can you present that data in a way that is best for the examiner to see, or at least when you're communicating with your in-house counsel, how do you make them understand as quickly as possible? So I certainly look at these as a tool that I like to share with my in-house clients, counsel, and that this gives us a common operating format or language to work on as we're discussing scope expansion, scope narrowing. Does it still cover features? Does it still can at the end of the day, if we make this change, can you still discover this? So there's a lot of very fine granular discussions that can go around this. But again, I always like to remind people that there's a 30,000-foot view as you're putting this through, because sometimes you get lost in this granular detail and say, oh, well, I'm only dealing with this one file history. This is why we like to do multiple file histories as we're walking through this, so we can understand co-citation. We can begin to do strength, weaknesses, and threat analysis in it. If we're looking at competitors, then we can start to see, what did they give up in prosecution? So if we go back to our blue ocean analysis of a couple presentations ago, we can then look, quite quickly to see, even though they may have disclosed something, they may not have claimed that it might be open for us to claim, in our own areas with our own methodologies, of course. And we can start seeing coverage overlap. So, and for those who do a lot of analytics, you can start to extract claiming strategies around particular products or around particular attorneys, especially if you're seeing how particular attorneys work particular examiners. You covered examiner analytics. We really haven't covered prosecuting attorney analytics, and so some of this starts to become evident in the we're looking at these summaries across a series of files written by a particular attorney, and we can start to look at both their work product. We can start to, and if you're in the licensing review, you can start to see limitations that are not evident on the face of the patents, that if you are dealing with a sophisticated licensee, that you will then have to make sure you address when they raise it to you in a licensing negotiation. So I'm sorry, everybody, I've been talking like crazy and talking all over the map here. Please ask questions. Yeah, Steve.
I think one use that you alluded to that has been pretty useful is because we've got all the claims and they're captured in this database, and because the database also allows you map claims, and when we say in this case, select the key limitations and then be able to present those in a matrix format so you can see all the limitations across all the claims in all the families of the case. Mm-hmm. We found that to be very useful for, it's different than the views that we're looking at here, but it's more of a limitation map that shows the commonality of limitations across all the patents in a given family. And what we've found there when we use that for high value cases where we want to do more work on them for mapping it, is we figure out there's a lot of times there are limitations that just keep leaking from one case to the next. They really shouldn't be there or don't need to be there. And they've just been copied over from one case to the next and assumed that they should be there. So you can see the Achilles heels of some of these portfolios of family claims. And, and you can say, okay, we should get rid of that limitation because that's in every one of these patents that were in this family. So it's good for that. Again, it's an overview that you don't normally get unless you've got time to lay out all the claims on your desk and just kind of peruse through, possibly 100 different claims to figure out which ones have which limitations, which is extremely tedious to say the least. Anyways, that's a use that has been very powerful for us.
Absolutely, and on an FTO side, especially if you have a family of patents you're trying to dispense with, if you can find that limitation that, again, the prosecuting attorney analytics, not an area that we've really spent a lot of time in, but, how they chase something down. They may have entirely taken the whole family into a dog-leg left when they meant to, drive straight down the fairway. So, to use my golf analogy, I mean, you can see where the attorney quality, in some of these writings really comes into play, and the human factor of getting something in an adverse argument with an examiner can sometimes lead you far astray, and then that first error is compounded by continuation work as well, unless you can kind of show the client where that mapping needs to go, or show the prosecuting attorney where that needs to go as well. So very good point, Steve. Thank you. Anybody else on kind of how we use it in the law firm? Or if not, let's move on to the client side or the corporation side. So as I mentioned earlier, a lot of our in-house clients like these tools because it doesn't require that they have to go back and entirely refresh their memory, especially if you're a large, if you have a large portfolio. Some of our clients have many thousands of patents that they have to manage and maintain. So as they're running through this, file history review, just even talking about a matter with the counsel, this makes that counsel discussion much, much easier, because then both of us are on the same page, literally, the same tab. And as we talk about this, then we can show them the pathway that this particular matter has taken. And then we start to talk, does this still cover what you're looking to cover with it? So, it's basically speed memory refresh for our in-house users. I find it also very, very useful as we're talking about landscapes and moving into FTOs or moving into opinions of counsel, that you have this tool available to you to quickly dismiss or keep things, or share and partner with your client. And the more your client understands where you're going with this, and you can show it to them quickly without walking through something, then you can walk through this in a great fashion, a great manner with your client. Also, as you're discovering through this, and I think we may have mentioned, I may have skipped this over in law firm, sometimes when you have an examiner focusing on a particular claim for being narrowed, and you have other claims in it, in many cases you can look at an amendment that the examiner is really pushing hard for, and understand why it is or is not a de minimis change, that you have the ability to accept an examiner's amendment and maybe get an allowance where, historically or language-wise, it may look like a narrowing to the examiner, but it won't be. So it helps you work with your partner, with your counsel, to talk about, the wordsmithing of a claim to keep you as broad as possible while still satisfying the examiner's desire to, find some way to narrow your claim. So it's that. And again, as we've talked kind of over and over again, a lot of multiple file history reviews where this becomes really, really powerful for in-house counsel. I'll start at the bottom first. Is that this tool also allows you to kind of really gauge the quality of your law firm. In the cases where you see statistically that your law firm is working through a high number of office actions, high number of RCEs, and walking yourself into a fair amount of problems and payments, then you can start to see how effective that prosecution has been, given the fact you've got all these different office action counts. And in many cases, the more times you go through an office action, the prosecution history of Estoppel keeps piling up and piling up. And this is where you start to have the discussion about, well, maybe we don't push this one through and put a record in place for the value of this patent. Let's file a continuation, and let's rethink our approach here. So that tends to be another area that I see a lot of value working with outside counsel and inside counsel partnering there. Claim planning, and this is a continuation aspect of our practice, where we have clients who like to do continuation work and kind of have a roadmap for how this goes. This is ultimately the Rand McNally road mapping for this particular claim mapping exercise, claim planning exercise, because it can see very, very quickly where the gaps are. As we mentioned back there with the marked up page of the claim amendment and claim elimination, you can see where, oops, at this point in this matter, we lost this particular feature. We should go back and recover that feature in another continuation. So, going down a long road here, but this is a tool that works with a lot of our other tools, that when you see something at a high level and you don't just stop and say that's a proxy for value. You can then pull this up, look down, and see what the heck is going on there, and is it really valuable when you get into claims? So unfortunately, for some of the licensing work that I've engaged in, this is usually a bit of a buzzkill, because you get down into this and you realize that prosecution history estoppel has taken away what you thought you were going to get out of it. So with respect to that, I'll stop for a second here and see if anybody else wants to jump on in and talk about how you've worked with these things. If not, let's keep moving. So, coming down here, I mentioned we have claim mapping. So again, if you are a licensing company or a licensing function in a company, this tool with our claim mapping tool is really, I think, the best way I've seen to plan your licensing discussion. You pre-answer anything that you have as an encumbrance. You make sure you've got an open set of applications that you can continue to target. It shows you how best to get into the position of targeting the evidence of use of a competitor. It gives you scope understanding. It gives you how to design, how someone might design around it. And you can get the detectability. And now, as we haven't talked a lot about valuation for this. And we will be, I think, in our virtual IP summit, we'll be talking about valuation, at least in one of the things. So please look for that and join in there. But I will say on valuation, a lot of the valuation of IP assets out there is conflated, because the sad thing about many of these patents is doing analytics is that conflation occurs when people don't get down and read in the claims. And so when we have someone come in with a number of patents, we try to look very, very quickly at it and find where the valuable matters are, so that they can either cut the price of that and still keep the valuable patents in that portfolio, or give them a sense that, even though you may be being asked for a value, that value may not have any basis in reality, because the claims have prosecution history estoppel, or that they foreclosed a potential evidence of use targeting in one of their other matters. So you can't get there if you're licensing strongly without getting through this level of detail, this level of granularity, and evaluation. If you are you're trying to work through an approach. So I find this highly useful in maybe blunting a lot of assertion approaches. But if you've answered these questions ahead of your assertion, this is this may be the right answer so that you get to a licensing conclusion without taking it to court. Just a thought. Anybody else on this slide, or we can?
Yeah, I found claim mapping to be extremely useful, especially in discussing freedom to operate with business managers who don't have much of a patent background. The dynamic nature of the spreadsheet that you're using allows a business person or an inventor to immediately see why a particular product might be cleared. And even on the fly, we've done this in a teleconference, allow you to see what features can be added or eliminated in order to render a product perhaps patentable. I mean, additional work needs to be done, of course, but this allows people who are not normally part of this process to see how it works in a very organic way.
Absolutely. And everyone, please remember, we're dealing with very, very complex essentially word pictures in our claims, so that as we are thinking about this, it also allows us to harvest the word, the word vocabulary of if we're targeting someone, so that we can actually help the next set of prosecutions that are kind of aligning to that assertion, to use the right words. For those who worked in litigation, if you're able to put in front of a jury, now here's our words, here's the competitor's words that we think are infringing, the same words. I mean, it's a very, it may not be truthful, but it's the same shorthand that happens a lot in jury work. So, one of the things that helps here is helps us be smarter about how we're bringing better patents to the table, and patents that really, do target something in some level of precision. So, anybody else? Otherwise, we can move on. Next slide. Okay, and so we do have a question here. I just want to, someone asked about this, explain a de minimis amendment. A de minimis amendment is when you can get to something that, when you can get an examiner to allow a claim with using a word that doesn't really narrow it. That's what I call a de minimis amendment. It basically, it's an amendment you can let yourself get through that doesn't really help your prosecution history, or it doesn't cause prosecution history estoppel. It's simply another word meaning almost the same thing. So, and this is something where we get to that as well. And one of the things that we try to do is we're working with clients in this, is to really help them understand the power of the words that used either in our filings, or the power of the words used in a competitive filing. And so, to that end, when you can get and show that visually to a client, you just get to the answer so much quicker, and you're much more effective in how that works. So with this slide here, these are the basic areas that I find a huge amount of evaluation. When I'm struck with whether this is a PCT application, but showing many parents, children, siblings, and grandchildren in complex families, this is where the first thing I will go is I'll start to pull file history summaries on this area. Although I am not a chemical biotech or genomic attorney, this is another area where you've got a high degree of precision, a high degree of word, very, very careful words, so you don't give away an entire species of your coverage in what you're going after. And with that, type of activity, you want to walk through this as fast as you can, but don't make an error. So I find these really, really good. And when you've got complexity, if I'm looking at a law firm and lawyer to evaluate how they work, it's a good tool. Anyway, lots and lots of good things here. We do have a question about who do we recommend for claim mapping tools. I like our tool because I don't know of another one out there that does things this way. Anybody else want to join here? We've got about 5 minutes or so left in this, so I just want to kind of help us get through some of the summaries here. People, if you have questions, please get in there.
Oh, Mark, I would just comment that there is another tool that can help people, I think, create sort of, I guess, I don't know if they're claim maps really, but help organize claim charts. And I can't remember the name of the tool, but there are at least one other tool that came out in the last year or two.
Yeah, I mean, I think you're thinking of what is it Turbo Patent or one of the Turbo Patent variants?
It's more of a patent kind of a opinion generation, helps you with organizing claim charts and stuff for like generating opinions.
Okay.
It's not really claim mapping like we do it, but it has some similarities to it. So it's I can't remember the name of it, but I'm sure somebody might be able to think of it and maybe pop it up like on our Q&A or message. So.
Yeah, so I mean, but there's lots of good tools out there. I mean, but this is what we find to be most effective and most efficient. I mean, we have literally centuries of experience inside the firm around this, and how we get good prosecution going through here. We're all about process and speed in this firm. We like to have process because it keeps our quality high. We like to have speed because our clients then can get an answer fairly quickly, so forth and so on. So these are the, in my mind, these are the key takeaways of this, and you've heard many of the other ones out there. This is, Steve, does Black Hills sell access to this? I know
They actually have, they've got their own
version of this.
copy of it, if you will, separate from ours, that they can help people provide it to people. So they do have, and Tom Marlowe, who's been on our series at times, can be contacted about that. He's at tmarlow@blackhillsip.com. It's MARLOW. If you're interested in talking to them, and also Ann McCracken at Black Hills would know about it, and or Jim Brophy, if anybody's dealt with any one of those folks over there.
So any questions or the rest of that, please, feel free to reach out to any one of us on this call. We'll help you steer you in the right direction. Janelle, any kind of closing thoughts you have here?
No, not really. I don't know of anyone else that has a mapping product like we have, though. I think it's unique, and I found it to be very valuable in my own practice, and in educating clients as to the details of patent infringement and freedom to operate.
Well, hey, Mark, I guess I'll just thank you, Janelle. And I guess I'll just jump in there and thank everybody, Peter, Janelle, Mark, Michelle, who's, organized these seminars, webinars along the way, and behind the scenes, Dan Yarmaluk, who's been helping us. And thank you for, all the effort and time that you put into the webinar series. And thank everybody that attended. We've had hundreds of different people to attend over the last 8 sessions. We appreciate you, your confidence, you're showing that we can deliver some interesting information. It's obviously a lot there, but hey, thanks again for everybody and attending, and hopefully we'll have some more webinars. Schwegman's got a destination IP program coming up beginning August 3rd. It goes for a couple of weeks, and it's our own sort of virtual IP seminar series. You should, if you don't have invite to that or haven't gotten one, you can reach out to Michelle Forsberg, who organized this today, and she can get you an invitation to that. But there's quite a few very interesting sessions in that with a number of different industry folks participating. So anyways, that's all we got for today, and thanks a ton for listening in.
Thanks, everyone. Thanks for your attendance. Bye-bye.